Who are the amicus in this case? Present today. Huh?
Sir,
अच्छा, आप क्रिमिनल मैटर पे है ना, स्टेज 2. मंजूर मलिक साहब का शायद नहीं है, तो पहले हमने लेट्स हियर द कॉन्स्टिट्यूशनल पॉइंट्स दैट वी हैव नोटेड, देन वील कम टू यू इफ यू हैव द टाइम. सो आप हैं, और कौन थे? सलाउद्दीन साहब थे, और यही दो थे? नहीं, और भी.
Mr. Khalid Javed Khan was there, but Mr. Khalid Javed Khan is unwell. He'll be here on the next date. He's down with flu.
Did you discuss it with him?
My lord, he told me that he will be here.
No, are you of the same view, or you didn't have any discussion?
No, my lord, we did not have a discussion. I called him yesterday, but he was quite unwell.
Mr. Salahuddin, do you mind? He's senior, he can... Okay. Zahid Ibrahim, you are for a party. Yes, okay, fine. No, he was a party. Here or no? Okay. Ji, please.
Last time I think, sir, Ms. Umar had sent her submissions in writing. I haven't seen them. But
I think Mr. Yasir Qureshi
have you filed anything?
My lord, we had filed some bulletins last time. I had also placed a note before your lordship last time when I was on my feet when this honorable court rose.
Okay. Do you mind referring to it?
Professor Qureshi,
because so much has been happening since then.
Yes,
that
your lordships have been very busy.
Don't assume we have read it. You have filed these 2 volumes. In addition to the 2 volumes, or just the 2 volumes?
My lord, I'll be submitting another one today, but those 2 volumes are there. I had, when your lordship was rising...
These are the 2 volumes. These are case law or whatever? Okay. Please proceed.
Yes. In the last 2 volumes, may I just identify what had happened? If your lordship takes a look at volume 1, your lordship will see. I'll just take your lordship through the index. I realize how busy you are, and there are a number of counsels your lordships want to hear. I had put in a comparative chart on the advisory jurisdiction. If your lordship just glances through the index of volume 1, then I had put in some judgments, Pakistani, Indian.
Volume 1A.
Volume 1. Volume 1.
There's 1A, it says.
There's 1A as well, but then there is volume 1.
Okay, the blue one.
The blue one. The blue one, right? Yes.
You want us to see the chart?
My lord, your lordship had seen it last time, but I may just show it to your lordship again. If your lordship would do is, may see, what I have done is that produce the respective provisions of the various constitutions in a table as compared to another, so that your lordship
leading to what conclusion?
My lord, that when your lordship is looking at a judgment cited from a foreign jurisdiction, your lordship will see to the extent the language is similar or not, and also when your lordship takes a look at the advisory jurisdiction provisions as they have evolved under the 1935 Act of India and then under the previous constitutions of Pakistan, what was the language, then when your lordship is examining your own judgment, your lordship will know that whether there's a difference or not. Your lordship will see one of the significant differences, that now the word may has been changed by shall in Article 186 of the Constitution.
Which word?
My lord, if your lordship takes a look at Article 186 of the Constitution, it is desirable to obtain the opinion of the Supreme Court on any question of law. If your lordship moves to paragraph 2, the Supreme Court shall consider a question so referred to it, shall consider a question so referred, and reports its opinion.
Original constitution had may?
No, the Pakistani constitution 73 always had may. Earlier constitutions in Pakistan had may. So the submission based on that was that where otherwise there may have been a discretion for this honorable court to answer or not to answer a question. Now this honorable court will have to look at the question and answer it. Of course, there is the jurisprudence of your lordship, that where your lordships have said that if the question is too vague, we will not answer it, or we will reformulate it and answer it. My lord, there are certain judgments which are then followed, which were then handed over last time.
What's according to you the question of law before us?
My lord, the question of law, according to me, the one on which I would be making my submissions is the one which is framed in the order of this Honorable Court of 21st of April 2011. And it was there also in the presidential reference. If your lordship takes a look at volume 6 of the paper books which are before your lordship, this is there as question number 1, and it is also as question number 1 in your lordship's order of 21st of April 2011. Whether the decision of the Lahore High Court as well as the Supreme Court of Pakistan in the murder trial against Shaheed Zulfiqar Bhutto meets the requirements of fundamental rights as guaranteed under Article 4, sub-articles 1 and 2A, Article 8, 9, Article 10A, due process, Article 14, Article 25 of the Constitution of the Republic of Pakistan. If it does not, its effect and consequences. That is really the pivotal question.
Whether it was considering the judgment, main judgment of the Supreme Court or in the review, it was considered or not?
What, my lord?
This question.
No, my lord, the submission is that it was not, and what your lordship will be looking at, your lordship can look at this entire matter, at this presidential reference from one of two perspectives. One is the criminal law perspective, whether the evidence of an approver ought to be given weight or not.
We want you to focus on the constitutional aspect.
That is my submission. I
think the latter is the easy part. The earlier is the more difficult one.
Thank you, my lord. I find the latter more difficult. So,
because you are basically a constitutional lawyer, maybe.
So, I'm very pleased to and grateful to your lordship for that out. So, I'll focus myself on the second. My lord, the question before your lordship really is that whether that decision meets the requirements of Article 4 of the Constitution.
No, but before that, if you can just focus on the other primary question, is the remedy of appeal as well as review was availed of.
Yes, my lord.
Now, how much room do we have, if any, under Article 186 in sitting in an advisory jurisdiction rendering an opinion? First of all, can we do so? And if so, to what extent?
My lord, may I just respond to the last limb of your lordship's observation first? In two cases within the jurisdiction of Pakistan, I know your lordship have looked at your earlier judgments and rendered an advisory opinion. One of them is the latest case in the Rekotik case, where this honorable court...
Is it reported yet?
My lord, I have had the advantage of reading the reasons of my lord Mr. Justice Yahya Afridi and of my lord Mr. Justice Mandukhel. The short order is there. The reasons of the other three learned judges, at least I have not had the opportunity of reading them, and I think the reasons of two may not be possible anymore, because only one of the three members is at the moment a judge of this honorable court.
I think it was said that there's no need to give any opinion. There's an order.
Yes, ma'am. And prior to that, my lord, there is the Governor General's reference. And that reference arose in the particular context of this honorable court in the Tamizuddin Khan case, having taken a particular view on whether a statute was constitutional or not, and therefore whether the Governor General could act in a particular manner or not, followed by the judgment in Yusuf Patel's case, where this honorable court struck down a number of orders passed by the Governor General.
And can you give the references, please?
My lord, I'll give you a lot.
And they're 186 or they're 185?
My lord, in the Yusuf Patel case, it was at that time an appeal, and the appeal arose, that is PLD 1955, Federal Court 387.
Early 1955 Federal.
55 Federal Court 387.
No, but if it's an appeal, we have no problem.
Yeah, my lord, no. What happened was that as a result of the decision in Yusuf Patel's case, because a number of statutes which had received the approval was struck down, the issue arose whether the government could function or not and how the government should function. And therefore, the Constituent Assembly having been dissolved, what was the way out? And therefore, a number of questions were raised in the Governor General's reference in PLD 1955, Federal Court 435. And this Honorable Court then provided an answer and suggested how it is to be dealt with. My lord, the questions of law which were originally referred to, your lordship will find them at 449, if I've got the page right. Yes, your lordship will see them at page 449. Your lordship will see what are the powers and responsibilities of the Governor General in respect of the government of the country before the new Constituent Assembly. The Federal Court having held in Yusuf Patel's case that the laws listed in the schedule to the Emergency Powers Ordinance could not be validated under Section 42 of the Government of India Act, nor retrospective effect given to them, and no legislature competent to validate such laws being in existence. Is there any provision in the Constitution or any rule of law applicable to the situation by which the Governor General can, by order or otherwise, declare that all orders made, decisions taken, and other acts done under those laws shall be valid and enforceable, and those laws which cannot without danger to the state be removed from the existing legal system shall be treated as part of the law of the land until the question of their validity is determined by the new Constituent Convention? So a direct question which arose from this judgment of this Honorable Court in Yusuf Patel's case was sent to the court and it was answered. This is just...
So the question was sent here? Where does it say?
My lord, this is the... If you
originally referred word.
Yes, my lord.
And then what happened later? They said...
This is the judgment, my lord, where that question is then answered and the Supreme Court...
Where is the question?
The question is, my lord,
originally referred were
page
suggested at
449, if your lordship may see.
These are the two.
Question number 2. If your lordship will see just before the indentation.
Yes, so there were 4 questions.
Originally referred were 1 and 2, subsequently 3 and 4 were also suggested, but your lordship